Good afternoon, everybody. I'm Christina Fox, the CEO of Tech Alliance. Thank you for joining us. As the Regional Innovation Centre for Southwestern Ontario, Tech Alliance is the place for dreamers, innovators, and world-changing ideas. And as a stakeholder in the economic prosperity of our province, it is our imperative to foster, harness, and protect these ideas. We're living in a time of change, not only as we navigate through a worldwide public health crisis, but also as we define and understand how to prosper in a knowledge-based economy, one where intangible assets define the narrative and drive prosperity in a way they never have before. Earlier this year, Ontario's expert panel on intellectual property released a report stating that intellectual property and data are our most valuable assets, yet a significant portion of IP created in Canada is eventually owned by foreign companies, and that only 2% of SMEs hold at least one patent. As Ontarians, we are known for being at the forefront of developing IP in critical spaces such as blockchain, AI, and machine learning. And we must pay attention to this ever accelerating economic trend and adapt our business strategies to be competitive as a global force. So as Tech Alliance remains committed to equipping entrepreneurs and future trailblazers with the knowledge they require to excel in this innovation economy, we are really excited to welcome an esteemed trailblazer herself, Natalie Raffoul. Natalie is a world-renowned IP lawyer and patent agent who is consistently ranked among the world's leading patent practitioners in the IAM Patent 1000 publication annually since 2014, and has been shortlisted as one of the most highly recommended patent prosecutors in Canada. In 2020, she was recognized in the IAM Strategy 300 World's Leading IP Strategists. Natalie is a member of the Ontario government's expert panel on IP and then transitioned to the Ontario government's special implementation team on intellectual property, also known as CITIP. Natalie holds a degree in electrical engineering from Western University and her law degree from Queen's University. I had the great pleasure of meeting Natalie a few years ago, or many years ago, through Western's Alumni Association. Natalie has strong ties to London and through her education and also through her profession. So we're so pleased to be working alongside Natalie and the special implementation team on intellectual property because tech founders and entrepreneurs with bold ideas across Southwestern Ontario are what fuel our work. And we are consciously seeking vital and valuable content to accelerate their growth, bringing you today's masterclass on IP considerations for entrepreneurs in the new economy. So before we get started with Natalie's masterclass, let me share a couple of key points. Everyone is muted on this call, and if you've got a question, go ahead and drop it in the Q&A feature located at the bottom of your screen. Today's webcast will be recorded and available on our YouTube channel. And if you'd like to keep up with everything there is to know about Southwestern Ontario's innovation economy, go ahead and sign up for our newsletter. We'll drop that link in the chat. So at Tech Alliance, we have a common belief between our board, our staff, and our entrepreneurs and residents, and the entire technology community that in pursuit of creating spaces where innovation thrives, we are focused on amplifying leaders in their fields. So understanding your legal risk in not protecting your IP and developing a strategy tailored to your own knowledge-based assets is why we're thrilled to be hosting today's masterclass with thought leader Natalie Raffoul. So Natalie, over to you.
Thanks so much, Christina. And I'm smiling because I think we go even further back to when you came up to Ottawa years ago for an Off to Western event, which was welcoming Ottawa students as they headed off to Western. So yeah, it's great to be back. I wish I was back personally in London. Some of my best years were spent in London, and some of my closest friends are still my Western friends. So it's great to be among you. So just kind of hopping, I know we've got a tight hour here, so we'll get into it. So just move through my slides. So that was a great introduction. Just a couple of things I wanted to note. Having started my own firm 12 years ago and involved in many companies now as an investor and as an advisor to a number of other small companies, I consider myself to be an entrepreneur like many of you out there. And I'm proud of the fact that I'm also a mother of three great kids as well. So I wanted to share that little tidbit about me. Another thing I wanted to state up front is I will start getting into some legal risks around IP. And of course, I am a lawyer, but I'm not your lawyer. And what I will say about IP advice is that, everything is very much going to need to be tailored to your particular company needs or what you're doing within your institution. So there's not a one size fits all. There isn't a rule book I can give you. And so a lot of this are going to be general commentary on things to be thinking about, but certainly if you have particular issues, you need to consult with an expert. So what are we talking about here before we started getting into strategy? So intellectual property, just to position us, I think there's probably in the audience, varying levels of sophistication. So when we talk about intellectual property, we're talking about this umbrella term that references all sorts of things that are really creations of the mind. So we're talking about inventions, we're talking about designs, the new shape of a vehicle, we're talking about symbols, images. But what's really important to understand about intellectual property law and the kinds of rights that are afforded through IP laws is that they're basically a type of exclusionary right that enables you, through the rights that you gain through intellectual property law, to exclude others from doing something. So it's not necessarily giving you the right to do anything commercially or out there in the public realm, but it gives you an ability to prevent others from taking advantage of your creations of the mind. Now, this is a pretty busy slide. I'm not going to get into all the details here, but just to impress upon you that intellectual property covers copyrights, trade secrets, patents, industrial designs, and trademarks. And these are sort of the better known forms of intellectual property. But there are other types of intellectual property, plant breeders' rights, for example, for those that are now in the cannabis space, when you're thinking about protecting new plant varietals. There are forms of protection for electric circuits. There are forms of protection for contracts and performing rights and celebrity rights. So there's all sorts of different types of rights. Some of the really key features to note, though, and why I highlighted this, is that they all have varying lengths of time that they last. For example, trademarks, which protect your brands, they can last in perpetuity. And so, for example, the look of a particular product, if you can manage to capture that as a trademark. So if you think about the Pillsbury Doughboy as a three-dimensional trademark, if that kind of protection could last in perpetuity, it's quite powerful protection. Patents, very powerful form of protection, because it prevents, with the protection of your invention or your idea, you're able to prevent someone from making, using, importing, or selling in that particular jurisdiction where you hold that patent for 20 years. Copyright is limited to the specific way that you express a particular idea or particular creative notion that you have. It doesn't protect ideas, and it won't protect functional components, which is why I noted in here that while software, yes, is protected by copyright, it won't protect the functional components or the ideas behind that software. And as you know, if you're out there and you've got any coding expertise, you know that there are thousands of ways to code a particular functional block. And so what it protects is that particular instance of source code, that particular way you've programmed that, but the protection will last quite some time, the life of the authors, and 50 to 75 years in some jurisdictions. And then trade secrets, another important form of protection. And depending on the jurisdiction, some countries have very robust trade secret protection, others not so much. In Canada, there are common law rights associated with that. But a key feature, and I know a lot of businesses say, well, look, I have an IP policy. It's a trade secret IP policy. We're a SaaS company. We keep everything in our box. So that form of protection is great as long as you can show that you've been taking steps to maintain that trade secret as a trade secret. So you need to take steps and be able to show that. So just kind of a little bit of insight there. Obviously my background being electrical, being high tech, I do a lot of software work. Just to kind of give you some fun examples as we get into this. So thinking about Instagram, Instagram would be protected under many forms of intellectual property. They would be taking advantage of copyright protection through the source code, because of course it's a software company. They would have trade secrets, so there would be certain algorithms that might sit on their servers that are not disclosed. Patents. This is actually an image taken. Now, Facebook owns Instagram, so this is a block diagram of an image taken from a Facebook patent that could be related to Instagram. Industrial design. So people forget about industrial designs, but it's a very powerful form of protection, particularly if you've got a graphical interface with a very unique look and feel to it. And I'm going to show you some design patents on the next slide. This is another great form of protection. Of course, you're familiar with Instagram as a word mark, but that of course it has all of those different slogans and icons that it uses that it also protects through trademark protection. So industrial designs, I wanted to highlight that because that form of protection is becoming more and more important. We're seeing many more filings in that area. And this is an example, if you look at your iPhone, this was an early patent, a design patent. And in Canada, I should say, they're known as industrial designs. In Europe, we call them designs. And in the US, they call them design patents, same form of protection. But this is an image of, you know, that unidirectional swipe to unlock the device, that particular design feature, not the functional notion of it, but the design features were protected through design patents. The functional idea is actually also protected through patents, but this gives you a sense of the kinds of things that can be protected through design patents. Here's the landing page for Google. This design patent, I just had someone check on this for me in the office, but this will expire still not until 2023. So, you know, we're very familiar with Google's landing page. What you see in dashed lines is what they have not protected through design patent. But if someone were to put a landing page, you know, for a search tool that looked similar to this, that had, for example, that I'm feeling lucky button, they would be infringing on this design patent. And this design patent was sought, I want to say 12, 13 years ago. So it gives you a sense of what kind of protection folks are going after. So as Christina mentioned, I've been involved with the Ontario government as an IP expert now for the last year and a half, advising them on how we're doing in Ontario in terms of the commercialization of intellectual property. And so when I was appointed, we were asked to review the innovation ecosystem across Ontario, and we did find some issues. And so I invite all of you to look at our report. It came out in February 2020. The link is shown here. It's not you obviously won't be able to click the PowerPoint to get to it, but it's out there. I invite you all to read our report. And really, this is a quote taken from the report. And Christine also mentioned this sort of same notion that really today IP and data are becoming our most valuable assets, and we really need to focus on them strategically as a country, you know, as a province, because really this is the basis of wealth today, and the accumulation and control of IP and data are now today's not only their most valuable business assets, but also their national security assets. And it's really been a shift. And when we talk about it, we're talking about the shift from tangibles, where we count value based on the particular commodities that you have, the products that you have in your warehouse, to moving to counting these intangible assets. What's the value of your brand? What's the value of your customer data? What's the value of the contracts you have in place with those customers? What's the value of the patents that you hold? What's the value of the designs? You know, the beautiful shape of your products is selling your products. When you look at the iPhone products, what's distinguishing them over their competitors? The beautiful design. Well, that is protected. And so really, when we look at companies today, you know, if you look at the S&P 500, the value of companies has shifted dramatically in terms of where we assign value, and it's over 90% in the intangible assets. And it's, you know, so we come back and we look at Canada. There's, you know, we've got a lot of sobering statistics to look at, and I'm going to get into a few of them. I don't want to belabor it, but just to give you a sense of where we're at. Canada, you know, of course, talking about ourselves as leaders in AI and clean tech, in advanced manufacturing, in the food technology sector. I mean, there's so many areas where Canada is you know, doing a lot of really great research and you know, product manufacturing, and we are innovating, but we're not necessarily protecting ourselves in those areas. And so, somber statistic here. I mean, you know, of the 1,600 patents that have been filed by Canadians at the U.S. Patent and Trademark Office, about 70% of them now are foreign owned. So a lot of what we are inventing in this country in some of these groundbreaking areas, which we know are going to be the wealth drivers of the future, these patents are ending up in the hands of foreign companies. So we're not deriving the benefits or seeing that value lift from holding those types of assets. And I just want to get into maybe a particular sector. I didn't not going to cover all the sectors, but if I were to show you patent counts in clean tech or advanced manufacturing, it'd be the same sort of situation. Canada is lagging, or when we talk about a resource sector. But let's talk about AI, because that's the topic that everyone loves to talk about these days. So who are the big holders of patent portfolios? So IBM having the largest patent portfolio. Just last year, Whitebow, the World Intellectual Property Office, reported that they've filed about 8,000 patents in that area. If you look at what the trends are, IBM is clearly leading, but we're also seeing Chinese institutions getting right in there. So we've got the Chinese Academy of Science, Etri, Jidian. 7 of the top 20 companies, 12 of the top 20 companies are actually Japanese. So it's interesting to see who is leading in this area. The USPTO actually just came out with a report on inventing AI and tracing the diffusion of AI with US patents, and took a look at the levels of increase. And we've seen an incredible increase in terms of the number of patent applications, growing from 30,000 annually to 60,000 annually. And just to see who's got a head start, look at these US companies. 47,000 patents, granted patents held by IBM, Microsoft, 22,000. But let's look at some of these other players. Amazon, e-commerce company, holds 5,000 patents in this space. And so when you look at these metrics, you think to yourself, okay, well, Canada being a 10th of the economy of the US, we should be looking at sort of assets in the realm of a 10th of that. And that's just not the case. We're not keeping pace with what our competitors are doing. And just to give you a sense of patent grants, it's the same players. I mean, they're primarily filing software patents nowadays. And so just giving you a list of the top USPTO patent grants. So who are the companies that are obtaining patents at the US Patent and Trademark Office? And I emphasize US patents because still today, when we look at a patent portfolio, the US patent is still going to be the most valuable patent in your portfolio. So just to give you a sense of the top grantees. And so who owns the world's innovation? Well, if we look at it just sheer patent counts, you can see the US, big circle there, China coming up, Japan on the left. I didn't show that, but you get the idea of sort of where we're at. And how are we trending? We're not trending in the right direction necessarily. So we're seeing Canada decrease PCT files, or international patent application files, and we're seeing a decrease in the trend. Now, this is a 2014 to 2017 statistic, but it could be, I mean, if you time shifted this now to the last couple of years, it's the same sort of statistic. We are on the decline in terms of international filings. And so some of the myths, and this is stuff, I mean, to give you some insight into the discussions by the IP expert panel and some of the advice that was given to government and some of the myths that we really need to debunk in this country. And I'll just kind of quickly read through some of them, but, adopting someone else's technology is innovation. No, it's not. It's someone else that owns that innovation, and we're simply manufacturing that or producing that here. Groundbreaking research is innovation. No, research is not innovation. We really need to get that nomenclature clear in this country. Research is a stepping stone to innovation, but innovation is the commercialization of ideas or research into products and services. So we really need to get that. We still continue to interchange research and innovation, and they're not the same thing. IP creation without ownership and commercialized is innovation. No, because we need to make sure that we're actually creating IP that we own in order to be innovative. Domestic only commercialization is innovation success. We want to see global winners. We want our companies out there winning globally. Innovation IP strategy is easy. No, it's not. We need to work hard at this. More R&D funding will lead to commercialization. No, I mean, it's about a continuum. Yes, we want to fund R&D, but we need to be thinking about how we move from, lab to bedside, bench to bedside, bench to products and services. How do we get these things into commercialized outcomes that are going to improve Ontarians? And whether it's in our health sector, we're talking a lot about getting relief, products and services to combat the pandemic. Well, how do we get those products and services out there into our health system, for example? And as a small economy, Canada can't compete with the global tech powerhouses. Well, yes, we can. And so on and so forth. So I don't want to belabor this, but you can see, I mean, we've got a ways to go in terms of debunking some of these myths. And as Christina mentioned, only 2% of our SMEs actually hold at least one patent. 59% of SMEs are only really slightly aware of patents. For the most part, there's a real lack of awareness. But what we do know, and this is actually data that the Canadian Intellectual Property has posted, but it was taken actually from the World Intellectual Property Office, showing that companies that hold at least one registered IP right, so that could be a trademark or a patent, are more likely to grow at growth rates of at least 1.5 to 2 times their counterparts that are not registering any formal IP rights, and are more likely, actually, valuations of companies that hold at least one registered IP right. Valuations are typically 4 times higher for companies that have registered IP rights. So it's an important thing that if we really want to bolster the valuations of our companies, we do need to be thinking about intellectual property rights. And when we look at us on those leaderboards, we're down there at the bottom of the G20, and that's not the place we need to be. Are patents and trademarks the silver bullet to an innovation economy? No, they're not the magic bullet, but they are one component that I think forces companies to say, okay, you know what? If I'm going to patent something, what am I going to patent? What is it that I do as a company that gives me a competitive edge over my customers? And I say to folks, when companies go through that process of trying to figure out what to patent, they force themselves to do a SWOT, to really say, okay, what are my strengths? What are my weaknesses? What are my opportunities? What are my threats? Forces you to take a look at your competitors. What are they doing? What are they patenting? What are they protecting? What's their IP strategy? And to become a little bit more competitive in that sense. So I don't want to be all doom and gloom, and I want to sort of move into recommendations here. So in terms of advising startups and SMEs, I'd like to cover kind of 3 things really, is to talk a little bit about the sort of the problematic assumptions that I'm seeing a lot of companies make that we really need to improve on, a couple of best practices to get into, and then obviously get into some of the legal issues and the business reality of just closing deals. I mean, we understand that. I mean, IP rights should not be an impediment to you getting those deals closed. So we want to live in that business reality, of course. So the first thing is, if you even want to be considering, protection, or you want to, so for example, you want a trade secret strategy, or you want to have a patenting strategy, public disclosure is your enemy in the beginning. You need to make sure that if you're going to go after a patent, for example, not only are you not publishing that invention in a journal article or on your personal website or some nonsense, but that you're not disclosing that to investors without an obligation between you with regard to confidentiality. So you need to put those things in place. Talking to friends, sharing ideas through your marketing materials. All of these can constitute public disclosure. And I see all too often companies coming to me and saying, well, I think the sales team might have actually had a conversation with the customer about what we could do or couldn't do. And it's that sales meeting that actually, divulges way too much. And we can't go after the broader concept. What we're left with maybe is some very particular thing that you've invented. And really, had we been able to go after that broader concept, that really the new concept around your product, that would have been a much better patent to seek. So we really have to, this is something I constantly keep pounding on, the public disclosure of ideas too early before you've figured out what your strategy is going to be around either trade secret or patenting is a big problem. The other thing is employee contracts. I do see this in contractor agreements. I see, folks with young companies starting out, maybe they don't have employment agreements in place, or they do, and they don't cover, for example, things like IP ownership. It may reference copyright, but it doesn't reference inventions. It misses something very important in Canada, this aspect of moral rights, which is something that runs with copyright. I won't be able to get into that in too much detail, but make sure that your employment agreements cover moral rights and that they are waived. They cannot be assigned, but your employees have an obligation to waive their moral rights. So they're not withholding any residual rights that can be problematic later. And this is really important actually in the software context, where your software developers are developing copyright, where there'll be moral rights running with that. So make sure that's in there. And non-disclosure agreements. So I see a lot of companies come to me and say, well, I have an NDA in place, and I've gotten into a situation where I'm working with a customer or I'm working with another partner. Well, who's a party to the NDA? Is it the subsidiary company and the parent company is not a party to it? So make sure that the entire family of companies that with whom you're sharing information is a party to that non-disclosure agreement, that confidentiality agreement. What does it cover? For how long? Do you have to mark everything confidentially? Because if you have to mark stuff as confidential, that's a very onerous requirement. I typically strip those out. Do you, what are the obligations around termination? Will you be getting material back from the other side if you terminate? What happens if you end up, and this is a real sticky one, I put this in red, what happens if you get into a situation where now you start sharing information with a potential partner and you've invented something together? Who owns those inventions? What if they invented something on your product? And this is something I get into here. You get into these, it's great to get into collaborative situations and joint ventures, but make sure the arrangement is clear from the beginning. And touch on things like, look, if we get into a collaboration and you invent something on my product, I'm actually going to want to own those rights, or I'm going to want to have the ability to license them. Maybe we can profit share what you come up with, but you don't want to all of a sudden have your product, compromised because your customer now has come up with a really important concept that you want to lay on top of your product. So be very careful about what's going to come out of those collaborations and plan for that. Freedom to operate. So a lot of times folks will get confused. They come to me and say, okay, I've come up with a great idea. Is it patentable? Well, yes. And we do find out, well, yes, it is patentable. There's nothing out there that's been done like this. There's no prior art, there's no previous patents, you're good. But that doesn't necessarily mean that your product that you're coming up with or your service doesn't infringe on someone else's patents. So you can still have freedom to operate issues, even though you've come up with a new idea. So let's say your product has, you've added, this is an improvement on something that's already in the marketplace. You're adding a component to an existing product. Well, that existing product may be patented by someone else. So you really do need to be thinking about your freedom to operate issues and make sure that just because you've gotten a patentability opinion doesn't necessarily mean you don't have freedom to operate issues. Trademark registration, this is a big one. A lot of companies get confused by business name registration. They go through that corporate incorporation process. They get a nuanced search which says, your business name is not identical or similar to anyone else's business name. That's a very different thing than a trademark search or a trademark registration search. The issue in trademarks is one of confusion, not one of substantial similarity. And so you want to make sure that you're thinking about trademark registration and you're making sure that that you're not picking company names or product names that are going to be confusingly similar with other competitors' names or products. And we'll get more into trademarks shortly. But so let's get into trademarks. So trademarks are a really important thing to be thinking about as a business. And I find because you can get out in the market and it's not a necessity right away, companies sometimes make some missteps early on with what types of trademarks they pick. And trademarks are very important in terms of distinguishing your goods and services from those of your competitors. And also a really great trademark enables you to really connect with the consumer. There's this lovely Nespresso image. But let's look at some trademarks just for some fun. So Grey Goose versus Smirnoff. What's interesting about these two brands is that it continues to be that we've done blind taste tests, and in a blind taste test, folks continue to pick Smirnoff, and yet Grey Goose in the marketplace is considered to be the better product, has that sort of higher esteemed brand. So it's interesting how trademarks can convey a real value in association with a product. Trademarks can also be really important in terms of how they're selected. So who remembers the Diamond Multimedia Rio PMP 300? It's a mouthful. That trademark, this is the earliest MP3 player. Nobody remembers this device, but everybody remembers and knows the eye-catching iPod. And today, that trademark has stood the test of time. And trademarks can, they can convey different things. Look at a trademark like Barf detergent versus Tide Plus. Barf, it conveys a good message in it, and to some consumers it will work. And so, it's interesting what trademarks can do, and they help you to really distinguish your products from someone else. So when you're thinking about selection of your trademarks, you really want to consider the strongest form of marks, and I always get into this conversation with clients in terms of what to pick. And so pick something that is inherently distinctive, that's not descriptive. Exxon, Xerox, Lululemon, these are great trademarks because they don't mean anything in the English language. They're coined terms, unique. Strong marks would be those kind of under that strongest mark category that bear no relation to the product or field. So if you think about Apple for computer products or Red Rose for tea, Puma, you know, there's some kind of association there, but it really has nothing to do with the product or service. Weak marks, and we see this a lot, is clients really inclined to use a trademark that really almost clearly describes what the goods and services are. And eventually you might be able to pursue, you know, you might be able to be successful with this trademark, but getting a registration to these types of trademarks can be very difficult, like All Brand for a cereal that is, you know, contains a ton of brand, not that distinctive. Chicken of the Sea for chicken soup, chicken noodle soup, not that distinctive either. And there's really a clear connection there. So these are not the greatest types of marks and won't necessarily help you to distinguish your goods over the goods of someone else's. Now, Kellogg's, of course, is a much more distinct brand. And so that would provide you with that distinguishing feature in terms of a trademark. What's not registerable, and this is important to keep in mind, is the name or surname of an individual who's living. So picking your own name and using that as your trademark can be challenging and not necessarily a good idea unless it's the type of name that also has some other very well-known meaning besides the last name meaning. Clearly descriptive of the goods and services, or deceptively misdescriptive is another issue. So, you know, Mexican for tequila, well, tequila is always Mexican. Saying something is organic when it's not organic. So any deceptively misdescriptive use to confuse the consumer would be problematic, or something that's very clearly descriptive. Searching is really important, and so I invite you. I mean, if you haven't spent time working with a trademark agent to figure out whether your brand is really distinctive, I mean, at a minimum, you should be at least doing your own searching, and keep in mind that it's not just going to be direct hits of putting in your name, let's say, in a trademark database or on the internet to see, okay, if I pick a trademark such as Wish, Wish could be spelt Wish maybe with a C tucked in there. And so if someone had a trademark to Wish with a C tucked into that mark, that would be very confusingly similar with yours, which was spelled the traditional way. So it's the sort of thing where you want to be very careful. If you're going to do your own searching, there's a real skill to this. And in fact, trademark searching is done using very complex computer algorithms. So I do encourage folks to do some searching at the beginning and to keep in mind things like words that sound the same or similar connotations. For example, if you're using the term rabbit and someone else has a mark for hare or bunny, that's going to be confusingly similar. So you can't go off and sell running shoes under the name rabbit when someone already is selling running shoes under the name bunny. There's probably going to be an issue of confusion there as to whether it's the same source of the goods. And so I wanted to get into a little case study to color this and just highlight the importance of jurisdiction, and just understand that IP rights are specific to a particular country or region. And, for example, if you've got a registered trademark in the US, that's not going to give you rights in Canada. So you really do need to be thinking about the jurisdictions in which you're operating and make sure that you're seeking protection in those jurisdictions. So vice versa, if you have a Canadian trademark right, that's not going to give you any protection in the US. And I just want to highlight the story. I mean, everyone's probably familiar with Target in the US and how they did come into Canada. And this sort of highlights the importance of trademark protection. So in the early 2000s, a Canadian fashion mogul, Isaac Benetov, registered the trademark for Target apparel for his line of clothes. And about a decade later, as we know, Target Corporation tried to enter and tried to expand into Canada, and they found their house brand, Target, was already in use in Canada and legitimately in use. Benetov actually had a couple of stores going at that point. He had a store in Sudbury, one in Nanaimo, and more than a dozen Target apparel stores opened before he brought a lawsuit against Target, the US company. So we ended up moving ahead, Benetov ended up moving ahead to prevent Target from being able to enter the market, and in the end, they ended up settling for an undisclosed amount, but the talk is that it was, definitely in the millions, and certainly far less than it would have cost the US company probably years ago to seek a trademark registration in Canada. So it's just a lesson that these trademark registration rights can be very powerful. And as we were talking about the value associated with it, for Beneteau, it ended up being very valuable to him because it ensured that he was able to maintain his businesses operating under his name, and at which point they came up with an amount that was suitable for him to step aside and allow them to operate under target, to allow the US company to enter. So again, if you're thinking about expanding outside your home jurisdiction, you've got to develop those strategies early on. And so for Target Corporation, they probably should have been thinking earlier on than at the moment they were about to enter Canada, whether that trademark was available to them or not. So in terms of best practices for patents, it's important to also be thinking about patent protection and some of the reasons why you want to consider patent protection. So I touch on this kind of quickly, but offensive reasons. So if you think that you've developed a product that is rather simplistic in nature, for example, and you think once someone sees your product, it's likely that they would be able to copy it. So for example, if you come up with a very simple consumer product or something that once someone has it in their hands, they can reverse engineer it quite quickly, you need to be thinking about infringement. So one of the reasons you want to patent the product is that so someone can't go ahead and infringe. The other reason you want to be thinking about patent protection is for defensive reasons. So companies in your space may hold a lot of patents, and so you want to have some patents yourself on some of the improvements that you're making in this space, so that if they come after you with their patents, you have the ability to fight back with your own patents, or at least be able to say to your competitors, look, you've got your market share, I have my market share, let's just sort of agree to leave each other alone. So a lot of companies you'll see, particularly in the resource sector and oil and gas, a lot of companies are holding patents really for defensive reasons to make sure that they can maintain their market share alongside their competitors. And then the other really important reason to be thinking about patent protection and IP rights in general is for funding. VCs like to see that, the investments that you're making, that these ideas that are giving you the competitive edge and these products are protected through, for example, patent protection. Government funders like to see patents. And nowadays, we've seen the recent announcement from the Business Development Bank of Canada that they are now going to be funding to the tune of 160 million. They're going to be able to secure funds against patent rights. So this, again, so now we're seeing security interest. And we've seen that for quite some time in other jurisdictions, but less so in Canada. And now we're going to see that you're going to be able to get secured debt against your patents from government funders. So that's an interesting development. So patents are important for a number of reasons, and I wanted to kind of get into just a quick example as to why it can really help level the playing field. Many of you may not be aware of this story of a small Toronto-based company, i4i, that had obtained a US patent in the late 90s that covered an XML editor function. And what they did back in the late 90s is they approached Microsoft and said, look, this is what we've developed. Would you be interested in incorporating this into your Microsoft products? And at the time, the developers said, you know what, the Microsoft development team said, this is really interesting, but I don't think we're going to pursue this. And then what happened is it ended up finding its way actually into Microsoft versions of Word 2003 and 2007. Thankfully, the i4i company actually did have a fully issued patent in the US. They managed to get some VC funding. They pursued Microsoft for willful infringement and did this all the way to the US Supreme Court of Canada and were successful. And Microsoft was ordered to pay about 400 million US to i4i in the end. And Microsoft was also ordered, there was an injunction to stop all sales that relied on that patented method. So they actually had to strip components of Word. And so if i4i hadn't had that patent protection, what would have been their recourse against Microsoft? So it's an interesting tale of a small Canadian company through its patent rights being able to pursue a large player and make sure that it gets compensated for its innovation. But there are myriad of examples, of course, of companies not being able to go after these giants, and that's something I think in the Canadian market we want to look at more closely and make sure we're supporting our companies where there is IP theft, we want to be able to help them pursue that. And so this was just an interesting case study where a Canadian company was able to do that successfully. So let's talk a little bit about the business realities of the legal risks quickly and risk management. So we know that you're not going to be able to get everything you want in your legal agreements, but the key is to really sort of, as you're moving through agreements with customers and partners and investors, that you sort of assess what are kind of the high risk things and what are low risk things and what you're willing to compromise on and not. And when you're getting into deals with anybody, you've always got to be thinking, okay, what does the exit look like? What does it look like when we get into a conflict? And also keep in mind, I see this all the time with companies I'm dealing with, is they've signed an NDA with this potential partner. Now all of a sudden they're getting into another agreement with this particular customer or partner, and that new agreement now conflicts with the old agreement, and they haven't managed to bring that first agreement into the new agreement. So we want to make sure that, you know, if you're signing all these deals, make sure that they accord with each other, they make sense, terminate the old agreements and move on to the new agreements. But I see, you know, a lot of instances of messy agreements with our SMEs here. So tidying that sort of thing up and keeping in mind, okay, what does the endpoint look like? What if we're no longer working with each other? What does that look like? The other area that I see as being really problematic is these indemnification liability clauses in contracts. And how much are you, you know, if something goes wrong with your product that you're selling, how much are you willing to cap your liability? How much can you push for in terms of, would you be willing to compensate for damages to the value of the contract or beyond that? Is your liability going to be unlimited for this contract, or, you know, are you going to cap this at some point? And I do see a lot of our companies, you know, going not capping it to maybe a multiplier of the contract value, but getting into situations where their liability is unlimited, which is just crazy, because that sort of thing could really bury a young company or a smaller company. So you want to be making sure that you're limiting your liability as much as possible, limiting it to contract values. And what's happening in instances of patent infringement. So if you're selling a product and now all of a sudden that product is infringing on a patent, or someone has alleged that your product is infringing on a patent, what does that look like? What will the indemnification look like? Does your customer get involved in the patent litigation, or does it stay out of it? You know, how do those things work? Thinking that through. And then warranties, I see this all the time in agreements, clients agreeing to say that, you know, this product does not infringe any patent. They'll warrant that, and yet this particular client doesn't do any patent searching on the regular, and it has no idea if potentially there might be a patent that pops up that the product might, you know, there might be a component of your product that is infringing a patent. So making these types of warranties in your agreements is a very dangerous thing. You know, softening that to language like such as I'm not aware, we are not aware, reasonably aware of any patent infringement. So softening that to say that at this particular time you're not aware is the way to go, versus actually making providing a warranty as to no patent infringement. Legislation compliance, and I see this a lot with you know, young companies. They're selling to clients in other jurisdictions, and they're agreeing to comply with all this foreign legislation that they don't really understand. Make sure that when you're complying with legislation that you know what the compliance requirements are, or question them and get copies of them. Make sure you've read through those. The other thing I see, and I try to you know, have clients really think through, is a lot of times you'll see contracts become terminate on an insolvency or bankruptcy, or at least when a company has taken steps to protect themselves in a potential insolvency situation. But when a company is going through a restructuring, this is maybe the time where you still want to be keeping up with customers, and you don't necessarily want those customer agreements to terminate. You might have better luck with working with your creditors by making sure that the agreements stay in place for that time while you're still in creditor protection. So negotiating agreements to say, look, if we are still able to deliver your product and service, even though we've taken some steps here to protect ourselves in an insolvency situation, you know, having the potential to be able to agree to that could be very important, helping you get through that sort of creditor protection period or that insolvency protection period, and helping you to reorganize. And another important thing is just thinking about your exit strategy. If you are in the event of selling your company to another company, one of the things that's really valuable about your company is probably the deals you have in place, and you don't want all of your customer contracts to be terminated upon an exit. So make sure that in an event of a sale of your company, that those contracts do transfer, that those agreements are assignable to a new company that purchases you. And I find that again is another area that's really overlooked. Make sure also that your customer, you don't want to have to go to all your customers and get consent to assign those contracts over. You might have to agree to consent, but again, what kind of consent? Is it consent that can be unreasonably withheld, or is it, does it have to be given, on a reasonable basis and cannot be unreasonably withheld? So think those things through in terms of what happens on an exit. And then finally, a termination. When you do terminate, you terminate because of a customer dispute. What are material breaches in an agreement? How much time is required to disengage from an agreement? So let's say you're providing a software as a service. How quickly can you disengage from that customer? And then who would bear the cost during that disengagement period? Again, I find a lot of clients aren't really thinking about what happens at termination, and this is something really to be mindful of again in your agreements. So on that happy note, on termination, I've terminated.
Natalie, thank you so much. I mean, this is really terrific. You certainly opened our eyes and left us with a couple of clear steps that we can take to ensure the ideas we want to commercialize, that we are able to follow through on that and understand how a thorough IP strategy can actually be used as a powerful tool for business growth. It looks like we've got 2 questions, or maybe 3 questions now in the Q&A. So why don't I shift over to that, if that's okay with you? We're at 12 minutes left of the hour, so a little bit of perfect time. So great timing. That was a lot of content. I really love how you set up sort of what's Canada's position, why is this important, how is IP playing a stronger role in the intangible economy, and what does that mean for entrepreneurs, founders on the call today? So the first question is, each entrepreneur on this call likely has IP protection needs. However, IP protection is cost prohibitive for most in their early stages. So what does it roughly cost for each type of protection? So maybe thinking about the continuum that you showed early in your slide deck. And then are there resources available to help early startups afford these services, subsidies, grants? It's a great question. It's one.
Yeah, it's a great question. And I'm been a big advocate of a first patent program here in Ontario, and I think federally we need it. The Quebec government instituted a first patent program for companies that didn't have a patent yet. And it was a good subsidy to really help you get some international protection. And that program was very successful. And I think now what the Quebec government is looking at is doing a patent program plus IP strategy. And we just found out this week, actually, now the BC government is announcing a first patent program, which is great. So I think this is all coming down the line. I think there should be more supports for this because it is an investment. It certainly is an investment. But there's sort of, you need to think there are cost deferral strategies with IP protection, and there are ways to do it in sort of a stepped, measured fashion that you don't necessarily file everywhere at once. I mean, you file in one jurisdiction and then you've got time to file in others. But there are programs out there, I know, through IRAP. There are ITAs in London and in Southwestern Ontario that can help you, and there are some purses of funding for IP costs. Unfortunately, SHRED, and I've said this for a long time, I really wish SHRED would allocate costs for commercialization, such as licensing agreements and IP costs, because I think this is important, and I think there's some work to be done on that. And then in terms of other funding buckets, I think those things are coming, but there are institutions that do offer some small purses of money as well. So I think it's
there appears to be another question that's almost a bit of a statement, given the low numbers of SMEs owning their IP, seeing 2% in Canada. It could be that the cost of getting in place is prohibitive. So probably a bit of that, but also a bit about the knowledge you shared today. That
I think that's it. I think people don't realize that the IP rights when they then go back to investors. I mean, having those patent pendings and filing. If you've got a really great brand and that is helping to sell your product, having a registration really helps to bolster your valuation. You're going to see higher valuations, which means those investment dollars that are coming into your company are going to be that much better because your valuation is that much higher. So I don't think people realize how it really greases the wheel for them. And so I think there's some work to be done on understanding the importance of it. But I agree. I think the fees are an impediment, and I think we need to support companies in that. I think, many other countries are doing that, and I think it's a critical thing here in Canada.
A couple of questions related to software, but here's one from the audience. Can you create patents on top of open source technology?
So that's interesting. So there are so many types of open source licenses out there. So it's really important to read and understand those particular licenses. So when you agree to use open source software, you need to understand what the constraints are. Some of them allow you to file for patents. Some require you, even if you file for patents, that you ensure that you're not going to assert those patents against others that are using the open source license. So there's all sorts of constraints around that, but you can. And particularly if you're using open source, but what you're developing and thinking of patenting is very distinct from what you're using, for the open source. But I think it's important, and a lot of companies are tracking their open source licenses and trying to understand, okay, they put this all in a matrix and they say, okay, we've got, these are the listing of open source licenses we're taking advantage of, and these are the restrictions. And so they are aware of how those are being used.
Okay, a question related to the Microsoft and the eye for eye story. How do you reconcile sort of the positive eye for eye story for them versus the patent trolls that are out there essentially blocking innovation of others? Can you comment on that, Natalie?
So it's interesting with the patent trolls. I find primarily, there are patent trolls certainly targeting smaller companies, which is frustrating. And so I do think we need supports for our Canadian companies, but I think the bigger patent trolls or patent licensing firms out there, a lot of times they're actually acquiring patents from now defunct smaller companies, so enabling those creditors now to get some funds from the investments that they've made. So sometimes these patent licensing firms are actually helping these small companies level the playing field against these bigger companies. And a lot of, when you look in the news and you look at big patent licensing firms, what are they doing? They're not suing small companies, they're suing large companies to make sure that those patent rights are respected. So I think they serve an important function, the patent licensing companies, in terms of leveling the playing field. But I do think there is some trolling of smaller companies that is problematic, and I would like to see some supports for that. I would like to see a 1-800 I need patent help here in Canada for those kinds of situations, so that someone can walk you through. Because a lot of times when you get those types of letters, it doesn't apply to you, but unfortunately the small company has to go through the exercise of reading the patent. It doesn't really understand it, and trying to come up with a strategy to deal with this cease and desist letter that they've received that's really aggressive. And I think that we're well positioned in Ontario, if we get this centralized resource up and running, to provide supports for our companies, so that initial, okay, this is what you got, this is what we recommend you do, we could do that. I think we could do that through a government agency or some kind of government mechanism.
Okay, thank you. So still on the eye for eye against Microsoft, the comment is defense of a U.S. patent held by a Canadian company in U.S. courts is expensive. Are you at liberty to talk about how much it would have cost eye for eye against Microsoft? And if you can or cannot, are you able to offer other strategies for Canadian companies in this situation, especially since we don't yet?
I would say probably to get to the U.S. Supreme Court. Every instance, my understanding is every instance, rule of thumb in the U.S., it's a couple $1 million for every level of court, at least. So it would have been in the tens of millions to get all the way to the U.S. Supreme Court. But in this case, with the VC backing, they were able to do that, and it ended up being a windfall. So let's say they did expend 20 million. It ended up working out quite well. Most things will settle, though. This is the thing. People think, I couldn't possibly take Microsoft all the way to the U.S. Supreme Court. The reality is 99% of things do settle even before they enter the courts. And a lot of companies we'll start getting into licensing agreements, or we'll settle. Many companies do respect intellectual property rights, so it's not always a doom and gloom. Unfortunately, in the media, we don't hear about all the settlements. We don't hear that these IP rights are getting enforced, and in fact, companies are moving into licensing agreements because a lot of that is confidential between the parties.
Interesting. Okay, so there's another neat question regarding AI. So it says, can you protect insights coming out of AI? So not referring to the algorithm per se, but the results and insights coming out of the exercise. That's really neat to explore.
Yeah, so the insights coming out. So if the insights coming out actually can then be used to produce some like new outcome. I mean, data in itself, so ideas in and of themselves, no, but if you now have come up with, if that feeds into some other algorithm that can be used for some other benefit, then you might be able to. Not sure if I'm answering that question that well. I kind of wanted to come back to it. Yeah. But in any event, I mean, it's the functional idea. So what you're protecting through patents, just to clarify, is you're protecting sort of the functional components, not necessarily the output at the end or the input at the beginning, but what you're doing with the input functionally, and then what comes out of that, the transformation into some kind of important output, and what the helpful application of that is.
Okay, so we've still got a few questions in the Q&A. There's two that I think we might focus on for the last sort of 2 minutes of the hour, and then I'll do some closing remarks if that's okay with you, Natalie.
Yes.
Awesome. So this one's a bit longer. So it says, my startup has a US provisional patent set to expire soon. We found the cost to hire a patent attorney to review our patent prior to filing for the formal patent is limiting us from moving forward, as we simply cannot fund it as a lean, self-funded startup, which is, something that we understand and is pretty frequent. What advice do you give to protect the idea? Is there any way to keep a preferred filing date until we're in a better financial position to move forward? The patent centers around the utility of our product, not a design. And how important is it for the provisional patent for establishing prior art? So really detailed, perhaps one to take offline, but are you able to?
Yeah, it would be something, I mean, happy to talk to this person offline later, but one of the things that we've done sometimes, if there's been no disclosure, we're pretty confident we're still ahead of the market, you could refile that provisional. You'd lose that earlier date, you'd lose that 1 year date, but you could refile the provisional, and that would move you up a year, and the fee of the provisional. I mean, you could self-file, or I mean, I never recommend that because the paperwork can sometimes be tricky, but it's a couple $100 to refile the provisional. And of course you lose the date, but there might be an advantage to that. But if you can get, sometimes if you can get an attorney also to just buy into what you're doing, maybe someone would be willing to put you on a payment plan, or do it for some, convertible debt in your company. I mean, there are patent attorneys out there that are willing to do sometimes these things for deferred payment, or for some kind of, equity or stock option later. It's just, yeah, you can, I mean, what I always say, and I said this to Christina too, is, when you're talking about getting advice for trademarks or patents, talk to 4 or 5, 6 experts. I mean, if intellectual property rights are this valuable, it's like your homes. You go and, when you're doing a renovation to your home, which is one of your biggest assets, Homes on Homes tells you go and get 5 or 6 quotes. Well, it's the same thing with IP advice. Go and talk to a few different patent attorneys and get a feel for what they're saying. And, maybe you'll get someone that really buys into what you're doing and sees the promise of it, sees the roadmap, the business roadmap, and is willing to help you.
Okay, and last question of the hour, and then I'll wrap with some closing remarks. Lots of examples of approved patents that are not actually new tech, and lots of them have been proven in court. How do we deal with this as a country and as an industry?
So that's a good question. Patent quality has been an issue, I think, and I think what we've seen over the last decade is a bit of a cleaning up on the patent quality side. So I think the patent situation is getting a little bit better. That's my sense of it. But I think this is something that you can, if you get a weak patent asserted with you, or a patent that's questionable, I mean, that's the sort of thing that we law back and say, look, I mean, this that you've patented, this has been done before, and I've got the proof here. Here's the journal article that sets out the details, or here's I went on the Wayback Machine and I noticed that your company actually published this, a few years prior to you filing for patent protection. So there are things, and you can come back with a strong position to say, look, this isn't new, and sometimes they just walk away at that point.
Okay. Well, thank you, Natalie, for leading today's masterclass. It felt like it was a packed hour, and at the pace of the intangible economy accelerates, and we focus on Made in Ontario approach. You've made it really clear what we need to consider in order to protect our most valuable assets that will inevitably drive our growth and prosperity. So we're certainly honored that you chose to spend your time with us today and shared the level of expertise that you have honed throughout your professional career. Thanks so much, Natalie. Thank you to everyone for joining us. Have an incredible day. Continue to be well and stay safe. Bye for now.
Bye.